A will can help ensure your things and affairs get cared for in the way you want after you die. This video will guide you through the process of creating a will in Louisiana. Step 1. Inventory your assets. Taking an inventory of your assets to create a will means listing everything valuable you own. This includes real and personal property. Write down any real estate you own, like your home, vacation home, or land. Also, list valuable items such as jewelry, art, collectibles, furniture, and vehicles. Money and debts. Record all your financial accounts. This includes things like checking and savings accounts, stocks, bonds, mutual funds, and retirement accounts like 401k or IRAs. You should also note any debts you owe, such as mortgages, car loans, credit card debts, and personal loans. Other things to consider include business interests, insurance policies like life insurance, and digital assets. Step 2. Decide how you want to distribute your assets. Choose who will receive your belongings and money. These people are called beneficiaries and can be family, friends, or charities. Specify any particular items or amounts of money for certain people. Explain how all your debts and expenses should get paid from your estate. Explain how any specific debts should be handled if necessary. Include a residue clause to decide what happens to any leftover assets. This is anything left after all specific gifts, debts, and expenses get paid. It's important to note that Louisiana law requires you to leave part of your estate to certain heirs. Certain heirs include young or disabled children. Ignoring these laws can cause legal problems and might invalidate parts of your will. Step 3. Choose an executor for your will. An executor is also called a personal representative in Louisiana. This is the person who you name to manage your estate after you die. Pick someone you trust and who agrees to take on this responsibility. This could be a family member, a friend, or a professional like a lawyer. If you don't name an executor in your will, the probate court will appoint someone. They usually start with your closest relatives. Step 4. Write the will. There are 2 methods you may have to write your will. This includes writing the will yourself or hiring an attorney. Hiring an attorney can help ensure the will meets all legal requirements. Louisiana recognizes several types of wills, including allographic and notarial wills. If you are creating an allographic will, write the entire will by hand. Sign and date each page. If you are creating a notarial will, you can type and print the will. Sign it in the presence of a notary and 2 witnesses. Step 5. Sign the will. Whether you are writing an allographic will or a notarial will, you must sign the will to make it legally binding. Step 6. Store the will safely. Keep the original will in a safe place, such as a safe deposit box or a fireproof home safe. Inform your executor and close family members where the will gets stored. You may also choose to record and file the will right after it gets signed. You can choose to record the will with the Louisiana Secretary of State. Step 7. Regularly review and update the will. Life changes, and so might your wishes. Review and update your will regularly, especially after major life events like marriage, divorce, or having a child. Thank you for watching. We hope this video helps you understand the process of creating a will. If you have questions, seek help from a lawyer. More information is available at louisianalawhelp.org.